Thank you, Madam Speaker. I rise today to speak to Bill 238. This bill would amend Section 738 of the Criminal Code so that courts could make offenders pay back community organizations like shelters, emergency services, and victim support groups that have faced rising costs, mostly because of human trafficking and serious drug offenses under the Controlled Drugs and Substances Act. This is a worthy idea, and I applaud the member for grappling with it. These organizations deal with the damage caused by crime every single day. They are the ones who respond to overdoses, who find safe beds for victims, and support survivors through trauma in my community and across Canada. When crime rises, their workload rises and costs go up. I am certain that the intent behind this bill is to recognize that reality and to help these organizations be better funded as a result. But, Madam Speaker, good intentions do not always make good law. While this bill seeks to create, while the law that this bill seeks to create sounds wonderful in theory, as a former litigator and adjudicator, I can tell you that in practice, all this law will deliver is more legal complexity, higher costs, more parties with standing to intervene in cases, and ultimately longer delays in a criminal justice system that is already stretched well beyond its limits. I truly appreciate that this bill recognizes that the costs of crime don't stop with the direct victim. When traffickers exploit vulnerable people, when drug dealers poison our streets with fentanyl, we all suffer. Our hospitals, our shelters, our police, our paramedics, our families are all left to deal with the aftermath. And this aftermath is one we see and deal with every day in Nanaimo Ladysmith. Under current law, judges can already order restitution when losses are clear and easily proven. For example, if someone breaks a window or steals property and the offender's caught, the loss can be connected to the offender, the cost can be easily quantified, and the offender can already be ordered to pay it back to the victim. What Bill C-238 would do, in theory, is cast a wider net, allowing community organizations and others to claim their costs, reflecting the real cost to society of those crimes. In theory. In the case of the broken window or theft of property, it could be the expenses of the local neighborhood watch, community associations, or the cost to the municipality of increased police patrols in that neighborhood. In the case of drug trafficking, these costs could include the increased costs of medical care, harm reduction supplies, security equipment, counseling for staff, and so on. I genuinely appreciate and support these goals. But causation is a problem. If a community organization wants to recover its costs from an offender, causation requires it to link those specific costs to a specific offender by showing that but for that offender's crime, the organization would not have had that cost. The idea being that you shouldn't make one person pay for another person's crime, or make one person, no matter how bad you might think they are, pay for something that the organization would still have had to pay for even if the crime hadn't been committed. Restitution works really well for direct victims, but cast this broadly, the problems mount until they become insurmountable. Take a shelter that helps victims of trafficking. It has rent, utilities, salaries, security costs, food costs, counseling. How do you tie those costs to a single trafficker's actions? What percentage is this one responsible for as opposed to that one? Or think about a hospital that treats overdose victims. How does a judge decide how much of an emergency room budget or how many doses of naloxone were used because of one particular dealer's drugs? The bill tries to help by listing examples of eligible costs, but that doesn't solve the problem. The issue isn't defining what the costs are. It's proving that those costs were caused by a specific offense committed by a specific offender, and it comes at the sentencing phase, which could be years after the arrest. Pulling that evidence together means a mountain of paperwork that will eat at the vulnerable time of frontline workers and ultimately hurt the very communities this bill seeks to help. It also means more time in court. This bill will turn sentencing hearings into mini civil trials where defense lawyers and prosecutors bicker back and forth over spreadsheets and receipts, arguing about which costs count and which costs don't. Documents need a witness to put them into evidence, diverting more resources from the communities, organizations, what we're trying to help. In the end, expert witnesses, consultants, and lawyers will be the only ones who make any money. This brings me to enforceability. Restitution isn't meant to be a fine or a punishment. It's meant to put victims in the position they would have been in, but for the offense. It's not linked to crime in general. It's linked to a specific crime and a specific offender. But the costs that community organizations faced are, in fact, linked to crime in general. And most criminals don't have regular bank accounts that courts can garnish. So what would happen if an organization successfully clears this causation hurdle? The court will issue a restitution order that will almost certainly never be collected, as my colleagues who have also spoken to this bill have explained. The organization will look well-funded on paper and may, in fact, even cease to be eligible for grants because, in theory, they have a judgment that they can collect on. They would usually even have 10 years to collect on that judgment, even though they will realistically never see the money. That just doesn't help anyone. Unrealistic restitution orders feel great on Judgment Day. They sound good, and they create the kind of hope that the honourable member who's sponsoring this bill spoke about in her remarks. But that hope is almost certain to be false hope, embodying the illusion of accountability without the reality of it. So what should we do? Conservatives believe very strongly in victim-centered justice, Madam Speaker. We believe offenders should be held accountable for the harm they cause. And we believe in supporting the people and the organizations that keep our communities safe. But we also believe that there are better ways to achieve this than what this bill is trying to do. We believe in mandatory minimum sentences for the offenders who traffic in drugs and create havoc in our communities. We would try fentanyl dealers as murderers. We could strengthen our asset forfeiture laws so that the proceeds of trafficking and drug crimes are seized and directed more directly to community recovery programs. We could work with the provinces to expand funding for victim services and trauma counseling. We could provide stable, predictable funding to frontline organizations so that they can plan ahead and deliver services without worrying about whether they'll get restitution from a convicted offender who may not, in fact, have any money. These are solutions that would make a real difference. These are solutions that would ensure that the money actually reaches the people doing the work without having to prove direct causation related to a specific case, without the need for participation in litigation, and without creating an additional burden on our already overtaxed criminal justice system. Madam Speaker, I have no doubt that the member who brought forward this bill did so out of a genuine desire to make the system better. I share that desire, and my colleagues share that desire. But as legislators, we have a duty to pass laws that are workable. Bill C-238 is just not a workable law. It creates false hope, complexity, and cost without achieving its goals. It will unfortunately not help victims. It will unfortunately not help fund community organizations. It would mostly benefit consultants, accountants, and the professional expert witness class, while adding cost and workload to our already overburdened courts. For those reasons, but with real respect and appreciation for the intentions for which this bill was crafted, we will regrettably not be supporting Bill C-238. I would be happy to sit down with this member any time and work on better solutions. Thank you, Madam Speaker.